lot of victims, and they're not just a generic term. They are parents, they are children, they are neighbors, and sometimes they are strangers. I've spoken with victims on the days of the offense, the week after the offense, the month after the offense, the year after the offense sometimes. Come in all shapes and sizes. They have very different wishes for what should happen in court cases. Some want the offender hanged, some want a lot of rehabilitation. There's just a wide variety of wishes. I think the newest category of victims is probably in the realm of substance abuse type crimes, which seem to be on a major increase. And the wishes of victims in those kind of cases may be very different than the wishes of victims in domestic or sexual assault. It's a wide variety. When I listened to the folks that came in to tell their stories, I listened carefully, and they seem mostly to fall into two categories, not entirely. One had to do with outcomes, and one had to do with the speed of cases. And I'm not sure that CACR 22 would particularly impact the outcomes or necessarily the speed of the case. In fact, if certain pretrial procedures are eliminated or made more difficult, it'll probably increase the volume of trials and thus delay resolutions overall. But first I wanted to talk about, more or less the state of the union. We have, as we know, a victims' rights statute. Victims, generally speaking, in this state are exceedingly happy with our victims' rights statute. The polling that's on the Department of Correction website indicates a satisfaction level of about 95 to 99% according to the questions asked. That's a very high level of satisfaction. We spend a lot of money on victim services in this state, in the millions, if not tens of millions. We have a strong victims' rights law, and contrary to what was suggested by the Attorney General's office this morning, it's mandatory. The rights are mandatory. It was so ruled by a Superior Court. It was not appealed to the Supreme Court as far as I know. So that is the law in this state, and I think, frankly, I was somewhat shocked to hear a suggestion that it was otherwise. We have amended the victims' rights statute, I think, 5 times to make it better. That is something we can do with a statute that we would find extraordinarily difficult to do with a constitutional amendment. And I think that's an important aspect to pay attention to. When the Marriotts came to the legislature, a year, 2 years ago, and said a fix needs to be done because of what we went through in our court case, it came to the legislature was responsive. We passed legislation to take care of the issue they brought to us, and they said they were satisfied with what the work that was done by the legislature. So that's really the 30,000-foot view of what we have now. A statute, victims' rights that work, can always be better, can always be improved. The nature of services will change over time. We're talking about automation of notice. That should be a significant improvement if that's an area that needs to be improved. All right. What this constitutional amendment will do in certain respects, and I agree that depending on whether that amendment is passed or not, it will vary this argument somewhat, but there are fiscal problems, there are policy problems, and there are legal problems. Let me address the fiscal problem for a moment. I have followed the lobbying and education function for the past year on this, and it seems as if there was absolutely no discussion about the fiscal aspect. I raised the question with an important person who sat here and got kind of slapped down for asking the question even. But it's an important question, and it's an important question because it's one of the reasons that some victims are opposed to bills or constitutional amendments such as CACR. Okay, we have right now, by and large, services provided in felony cases, domestic assault, and the like. That may be 10, 12, 15,000 people a year. It's hard to get the numbers, by the way. Okay, that costs several $million. If we add misdemeanors, which this bill does, there are 4.4 times as many misdemeanors as felonies. Now, granted, maybe not as many people who are involved in misdemeanor cases will ask for victim services, so let's only triple the size of the program instead of 4.4. You're going to add people who are proximately harmed, which is not in the current law. That's going to get huge. If you keep corporations and insurance companies in, it's going to get larger and larger. There's two ways to approach how we will deal with that. And this is where the rub comes. The first part of what we approach is to raise taxes. And let's be honest. If you want to take a program that costs millions now, or possibly 10 million, and you want to quadruple it in size, then be prepared to substantially raise taxes. Some people don't mind that, some do. Maybe we'll even get an income tax out of it, who knows. The other option is to say we have a pot of money to spend on victim services, and rather than spending it on the current group, who are largely domestic and sexual assault victims, that we're going to take that same money and we're going to give it to this number of people. And then each of the people who currently are receiving services will get a small fraction of money spent on them. And that's why groups like the Maine Coalition on Domestic and Sexual Assault, came out against their version of Marsys law, because it implied a serious diminution of money being spent on current recipients of services. I think that's an issue that's being dealt with in Illinois also at the present time. That's some of the fiscal aspect. You try to find out some actual costs, it's almost impossible. Policy. The Attorney General and the representatives answered a number of questions. Some better in my book, some not. Full and timely restitution. Let's just take that. It's kind of an easy one. What does that mean? I mean, normally restitution is a statutory concept. It's not placed in constitutions because it varies from jurisdiction to jurisdiction how it's done. All right, this says a victim would have a right to full and timely. Okay. Even if we take out the full, which the amendment suggests, it says the victim shall have a right to timely restitution. Well, what does that do to the current system where if somebody can't pay all up front, they pay $10 a week, or $10 a month. It may take years and years and years, but those go on a long time. Well, no longer, because the victim has a right to timely restitution. So what happens then to statutes and policies and procedures which allow the defendant to pay as best he or she can? Well, when we put in the Constitution a constitutional right to timely as well as full, The only other way to go about it is to say constitutions are designed for the state enforcement of rights. That's why we have constitutions. So if a victim has a constitutional right to full restitution and the defendant can't pay, the defendant's locked up for 10 years, then the victim goes to the state and says, you have guaranteed me the right to restitution, full and timely. I want it. And you're the guarantor. The Department of Corrections collects about $250,000 a year in restitution. That's just the Department of Corrections. It doesn't include the courts and the like. How much is uncollected a year? I don't know. I tried to find out briefly. But I would suggest, you know, it's certainly got to be in the excess of $1 million. So add that to the $32 million budget and the larger victim services that we already have. So that's the problem in taking something and putting in the Constitution without really thinking about the implications in real life, how that's going to happen. We don't know. Folks sitting in that chair over there can give a good guess. Maybe they're right, maybe they're wrong. They've got a point of view that they're trying to promote, and maybe their point of view is not going to be accepted by the courts. Same thing about the role of the prosecutor as an advocate for the victim. What we heard today was, oh, no big deal, we're just kind of doing it already. The words in the Constitution would be, the attorney for the government may assert rights. That's different than saying, by the way, the victim feels that he shouldn't be released on $10,000 bond, it should be $1 million bond or whatever. That's different. Asserting rights in an appellate court is very different. And it's really going to change the role of what prosecutors are in this state. In a larger context, the idea, and we've discussed this at the hearing, we discussed it today, of when is a victim, it's an important concept in our country. I grew up with the idea that a crime is not committed until a judge or a jury says a crime has been committed. And I heard in my practice as a public defender in an adjoining state, judge after judge after judge correct prosecutors who refer to victims as victims in the trial instead of complaining witnesses because it prejudiced the jury. And prosecutors were instructed, you do not do that. This would take the definition of victim before a crime has been established and make that permissive according to our Constitution. And anybody who says that that won't degrade the presumption of innocence in our society, I think is really wrong. So I can go on. I don't think CACR 22 can be saved, and I don't think it should be saved. Because it has so many problems, it should be a statute, because then we can fix problems as they go along and not do what I think South Dakota is trying to do, which is pass a second constitutional amendment trying to undo the first constitutional amendment. Thank you. I know